right, you're still here on the AM show, and we're getting into our main conversation for this morning. It has to do with the 499 law graduates who were seeking to gain admission into the Ghana School of Law. It turned out that they were denied based on the fact that the results of the entrance exam they sat was, or they wrote, the Ghana School of Law says they didn't pass or they didn't qualify. But then they've made the argument that what the Ghana School of Law actually means is that they didn't get 50% in both Section A and Section B. And they're saying that that's unfair. Now, they staged a demonstration. They've embarked on a street protest. They've actually gone to court. They've petitioned Parliament. Now, Parliament on Friday indicated that, or directed the Ghana School of Law to admit these students. I have with me the South Dai Member of Parliament, Roxanne Nelson Afia-Mekbo, who is a member of the Constitutional, Legal and Parliamentary Affairs Committee. And then Jonathan Alua, a lawyer and former SRC president at the Ghana School of Law. He is joining us via Zoom, so we'll be getting to him also in a bit. But I'd want to start with Mr. Afia-Mekbo. Now, Parliament is saying, and welcome, good morning and welcome to the show.
Good morning, Israel, and good morning to my good people in South Dine, Peki, Pali, Peve, and Tongo. I traveled, I just got back.
Okay, you went to them? You went to?
No, I took a quick trip, parliamentary duties outside, so I couldn't visit last weekend.
Outside the country?
Yes.
Okay, you had a visa?
It was a visa-free country.
That's just by the way.
Yes.
Okay, so what exactly is Parliament asking the Ghana School of Law to do?
Yes, it's come to the attention of Parliament that on the 14th of May this year, the General Legal Council, acting through one of its bodies, that's the Independent Examinations Board, put out a public notice to the effect that they were receiving applications from persons who were holding LLB degrees to apply to sit for the entrance examination that they will conduct.
Yeah.
And so in that notice, they put out all the conditions and rubrics governing the conduct of the exams. And so Israel, particularly if you look at paragraph 5, paragraph 3 of that notice, it was very clear that every candidate that obtains the minimum pass mark that will be set by the General Legal Council will be admitted. It was not even said that will be admitted, you will just be admitted. And the minimum pass mark as set by the General Legal Council is 50% for the exam. Now, persons rushed to go pay 550, I'm told, and wrote these exams. They were in excess of 2,700, I'm told. And eventually, the results came out. When the results came out, it was discovered that about 2,289 had obtained the minimum pass mark of 50% or more. In fact, the pass mark ranged between 50% to 84%.
All right.
So, but somehow, the General Legal Council released 790 names as being the pass mark. So there is...
As being those who had passed?
Yes, as being those, as the pass list.
Okay.
So those, naturally, those who also wrote the exams and didn't find their index number on this 790 pass list, agitated for the publication, the publication of the full list, which means the over 2,700 names should be published. So that the pass mark will indicate, or the pass list will indicate from ascending order no, from a descending order, the highest to the lowest of the pass mark. So what happened was they released the raw scores. Then trouble struck. Why? Because some persons discovered that even though they got as much as 65%, their names were not among the 790. Some discovered that they got 55%, but their names were not among the 790. Someone even said that he got as high as 68%. Her name was not among the 790. But in scrutinizing the 790 list, so many students got just 50%.
Yeah.
Do you understand what I'm saying? So if we were taking the cutoff, if the cutoff were placed at a certain mark, somebody who got 68 and is closer to 84 should feature in there. So there were agitations. So the response of the General Legal Council through the Board of Legal Education, which is the law school, now was to issue another notice. And this notice was to the effect that, now the criteria was that you were to obtain 50% or more as Section A of the paper, and also 50% or more as Section B of the paper, in order for you to qualify. And Israel, I've been writing exams ever since I was about age 5. I've never seen this kind of thing. Never. And I also attended law school.
Yeah.
Never. So clearly, even if this is the new formal law school intends to adopt, so be it. In any case, in our time, there was no even any entrance exam.
Yeah.
We just walked in and studied and wrote the exam set course by course, and we graduated.
Okay, so then Parliament comes in.
So hold on. So the agitation has been that, okay, so admit the numbers who, pursuant to the earlier conditions, have crossed 50%, so that in the future we can deal with this. The GLC won't speak to this issue. Until today, as we speak, they've not spoken or not addressed the issue. So the matter, like I opened my remarks, this came to the attention of Parliament. And Parliament feels that no, it cannot be, we can't allow this to happen. And I've heard people making all sorts of comments whether Parliament is closed with power. Really?
Yes.
We are fully clothed with the powers.
You see, before we actually get to that,
yes,
I'm wondering, have you actually approached the GLC and told them, okay, come to us and explain to us why you are refusing to, respond to the concerns of these students?
GLC itself hasn't come. When this matter came to Parliament, we were on recess. And the matter broke for about 3 weeks or so before we came back. So we have been hoping that, pursuant to all the agitations, GLC would
say something.
Will say something and even explain, give reasons. They won't speak, they won't talk to anybody. Now, you ask whether Parliament had approached GLC.
So you invite them?
In this circumstance, we don't need to invite GLC because time is of the essence. They are proceeding with arrangements as if there's nothing happening. They've issued timetables. They've asked students to go onto the website and get and be assigned their campuses and orientation and all that. So clearly, they are not minded to listen to anybody. So the best thing for Parliament to do is to give the directive. In any case, Israel, the law school admitted over 1,000 students last year. In fact, 1,045 is what they claim they did, but we have evidence that they admitted more than 1,045. So if a school that admitted 1,045 just 12 months ago and is running what they called multi-track system, what prevents the same school from admitting a similar number this year? Indeed, if we want to talk of progress. So clearly, it appears that the General Legal Council is adamant in these matters. Now, very interestingly, they have been sued by these students. They've taken the matter to court. If you read the affidavit in opposition to the motion filed by the students, it's such a tragedy.
Affidavit in opposition to the motion filed by the students?
By the students.
Then probably by GLC. So GLC has filed? Or?
No, GLC has responded
okay.
to the application on notice. And so they are resisting the grant of injunction. Now, in doing so, for instance, in paragraph 16 of their affidavit, GLC says that they never put out the notice, the notice that if you get 50%, you qualify, you'll be admitted. In one other paragraph, they are citing discretionary powers. But our Constitution is very clear in Article 296. You cannot exercise your discretionary powers whimsically, capriciously. You understand? So they are walking themselves into a ditch. That is why Parliament wants to rescue the situation. In any case, in about 2 or 3 weeks' time, you'll be coming before Parliament for money, for budgetary allocations. We are supposed to even do performance review for their financial performance this year, for the activities that we allocated monies for them this year. So, admission of students, training of professional students, and all are part of the functions of the Board of Legal Education.
It brings us to the other question, which you actually alluded to. Yeah. Does Parliament have the power to direct the GLC or whichever institution to admit these students?
Okay, we do. Let me refer you to Article 103.3 of the Constitution. It says that committees of Parliament, okay, Article 103.1 says, Parliament shall appoint standing committees and other committees as may be necessary for the effective discharge of its functions. Now, 103.3 says, committees of Parliament shall be charged with such functions, including the investigation and inquiry into the activities and administration of ministries and departments as Parliament may determine. And such investigation and inquiries may extend to proposals for legislation.
Okay, so I see ministries and departments.
Yes. The General Legal Council is a statutory body set up by an Act of Parliament, Act 32. In fact, 3 years ago, when the issue about the admission of the 128 out of the almost 3,000 students, they came before us. And one of the things we did for the General Legal Council was that there were, those days when you passed, about 3 or 4 years ago, when you passed the entrance exams, you were not immediately admitted. You had to go through an interview. And the complaints were that they were using the interview more to frustrate people. So we took out the interview component.
Okay.
So if we don't have the power...
You're saying that, I mean, based on that, you actually have the power.
We have power. We have directed.
I want to get to Jonathan Ganlua. He's a lawyer and former SRC president, Ghana School of Law. He's joining us via Zoom. Good morning to you, Jonathan. How do you read all of that that's going on, especially the bit about Parliament directing that the Ghana School of Law admits the 499? I suspect...
And Israel, before Lua comes in, let nobody confuses what's happening to the other issues or what has happened in the past. This one, they have passed.
Okay.
They have passed the entrance. The GLC is arguing inadequacy of fiscal space.
Well, they haven't actually brought that in. So for now,
look at the affidavit in opposition. I'll refer you to that. I will forward it to you.
All right. So, Jonathan, where do you stand on all of this? You must be happy that the Parliament is on the side of the students.
Good morning, Israel, and good morning to the honorable member of Parliament and everybody listening and watching you. Israel, I'm completely excited, that somebody, not even Parliament, somebody has spoken out about the injustice. When I saw the argument about the constitutionality of the directive and all of that, I wasn't swayed to even join, the bandwagon and argue about whether or not they have the power to do that or not. This is a situation where clearly the GLC doesn't have the power to act in the manner that they are acting, but we've all folded our hands in despair and we are watching them. And I jokingly said that if our beloved farmers even want to direct the GLC out of frustration to do what they should do and undo the injustice that they've, meted out to these students, we should support it. And so I'm completely with Parliament, devoid of the constitutional argument of whether or not they have the power. Somebody has to call the GLC to order. As the honorable member said, nobody is allowed to have that level of arbitrariness. You cannot be a body making decisions capriciously or whimsically, and your defense would be that you have discretionary power. Now, this is a practice that has gone on for so long. In my year, as the honorable member was saying, we were 1,801 students who applied for this exam, 456 passed. Now, they admitted us, and in the next year, which is what caused the demonstration and the police brutalities and all of that, if you would recall, they admitted 128 students out of 1,820. Okay. That was completely hilarious, and so we demonstrated and all of that. And in the next year, and people are reading political signals into this, and I think everybody has the right to make analysis of this situation because it doesn't really make sense. They admitted 1,045 students and decided to introduce what they call a multiple track, as the honorable member said. They divided the students into 3 groups, and they've been doing that for a while. They are now progressing to part 2. Now, this year, following the same scheme, now it must be said that Israel, my year group, the pass mark was 50. There was nothing like objectives and, section B, section A. It was 50. Once you hit 50, you are in. It was the same for the 128 students. In fact, as a matter of fact, before us, there was a year where the pass mark was 46. There was a year where they took students who had 46. So we had all assumed and understood that the pass mark now is 50, and everybody knows that. And this year, clearly because they don't have space, as the honorable member has said, that's all they are, saying in their affidavit in opposition to the application by the students. They are saying they don't have space. And so they decided in a knee-jerk fashion to say, okay, you know what, let's massage the numbers. If we stick to 50, we are going to have 1,000 students, a little over 1,000 students, and that will be problematic for us. So why don't we, find a means of reducing numbers? And that's how they arrived at these objectives and theory thing. And that's completely, unlawful. And I congratulate Parliament for being bold, but this is not the first time we've been here. If the honorable member will remember, we came to Parliament, we came to them complaining about remarking fees. At the time, remarking fees stood at 3,000 cedis. So you had to pay 3,000 cedis to mark one paper. Now we came to Parliament investigated this matter, issued directives, and Israel, they did nothing about it. This is a body that should understand the law better than anybody, but they did nothing about it. It took incessant complaints, a lot of demonstrations, lobbying for them to finally reduce it. Parliament recommended 500 cedis, but we only got a reduction to 1,500 cedis. So I think all I'm trying to say is that Parliament is the legislative wing of Ghana. They are one of the most powerful institutions in this country. And if we have them coming on board to support the plight of these students, I'm all in for it. Let's forget about, the technicalities and all of that. Let's see where this goes. I am personally skeptical that the GLC, given their past reaction to things like this, will obey the directive. I hope they prove me wrong. But even if they don't, there's a bit of political compulsion out of this directive from Parliament.
All right.
I'll really be...
So, Jonathan, the GLC can say that, well, we don't have the spaces. You can say that, well, you admitted over 1,000 last year, and so you should have at least 1,000 slots. But they'll say, well, we looked at the way we operated there with over 1,000, and we realized that, well, we have challenges, and so we can't continue that way. What can be done about it? They're saying we don't have the space.
Israel, that's not true, because this year they are not using their facilities, I'm told. This year, For the Part 1 students, they've rented space at UPSC. So this is a school that understands that we can take measures to accommodate numbers because they don't have physical space, and that's the point you'll be making. You know, we can't sit down for over half a decade. We've been at this training lawyers in the country, and we didn't know that a day will come when we need more space to house students. I won't talk about the law village they are constructing now, but they are going to rent space at UPSA. So Israel, if they are really minded to undo the injustice that they've done to the 499 law students, they will find space to house these people. They will rent bigger space and give them the legal education that they are entitled to because they passed the entrance exam.
All right. Thank you very much, Jonathan. But
may I add a few words? Now, Israel, it's ironical that the General Legal Council, via the Board of Legal Education, is crying about inadequacy of funds to complete the law village. Each student in the law school pays annually about 15,500 annual fees. If you admit 1,200 or 1,300 students, multiply that by 15,000.
You're looking at, 15 million?
It's about 20 million.
Okay.
All right. Now, if for a year, you have about 1,000 students in Part 2 and about 1,300 students in Part 1, that gives you about 2,300. 2,300 students times 15,000. The law school can complete the law village in a year or two with this kind of funding. Importantly of all, with the advent of COVID, the law school now trains they use Zoom to deliver lectures. I know students who recently completed and graduated. The whole of this year, prior to their exams and graduation, they were using Zoom. They were sending them lectures via Zoom. Assignments were delivered by Zoom and answered and also returned to the lecturers via Zoom.
So it's saying they can expand their classrooms
virtually.
So
now by the law school's own introductory policies, they have reformed how lectures are delivered. So you don't need 1,000 students to sit in situ, physically in a classroom, to deliver lectures. And that is part of the forward-looking reforms. So this kind of reforms should rather encourage the law school to admit more.
Why, I mean, in the light of all the things that you said, why then will the GLC necessarily want to frustrate students or people from obtaining the law degree?
It beggars the question. Israel, this is a country that is saying that...
I want to believe they must have some very good reason.
They are not speaking, so you can't even think for them. Because you see, the legal profession is arguably like the medical profession, but the medical profession is no longer even that. The legal profession is the only profession which, when you graduate, you don't need the intervention of the public service to get yourself into employment. You are able to set up quickly and earn a living. In fact, the law permits you to employ. The only thing the law doesn't allow you to do is to recruit your colleague lawyers until you attain age 7 at the bar. So as a young practitioner, after your pupillage, you can set up your chamber.
Yeah, and an entrepreneur.
And the entrepreneur and recruit workers. They will work for you. When you attain 7 years, you recruit other lawyers. So we are really, it's really strange that such an opportunity exists for us to train more lawyers. We are frustrating the process. Israel, all the district assemblies in this country, about 99%, they do not have lawyers. Meanwhile, as a member of the Public Accounts Committee, every year that we interrogate Auditor General's report, this issue of getting lawyers, legal officers to help the assemblies to reduce some of these infractions becomes very clear.
Is it the case that the lawyers are not available, or the lawyers are available, but they prefer to be in Accra?
No, that is not the case. If I graduate and my district, Southern District Assembly, is willing to employ me as a legal officer, a lot of young lawyers are willing to take it up. Because we are already decrying the fact that we don't have enough lawyers. In the whole, Something and I had a program on Newsfile about 2-3 weeks ago, and he put out some interesting statistics. A research was conducted by my own classmate, Dennis Ejejumo. It says in the whole of the Upper East, the Upper East and Upper West, we have only about 13 lawyers. And the whole of the northern region, the northern sector, we have about 32 or 33 lawyers. Serving a general population of about 1.3 million people. I mean, look at the ratio.
All right, so back to this directive. It was issued on Friday. Have you heard any word from the GLC or any indication that they're likely to comply?
The likelihood to comply or the non-likelihood for them to comply now doesn't lie with them at all. They have no choice. But what I want to say is that the directives came on Friday, at the close of business Friday. So the directive will be prepared by speakership, the Speaker's Secretariat, and through the clerk will be delivered to them. That's a procedure. It will be communicated. In fact, the directives were, after the resolution, the directives were directed at two entities, the Attorney General himself and the GLC. Because you see, the Attorney General too is represented on the General Legal Council. So, pursuant to Act 32, he has oversight. So we are asking him, as the Minister of State, to instruct the GLC to admit the students. That's one. We are also further asking the GLC itself, as a council, to take steps and admit the students.
Okay.
We are not saying anything further than that.
So you've indicated, take steps to admit the students.
Yes.
The steps they are supposed to take could be take a month, 2 months.
No, if we say admit them,
year.
The admission is today. In fact, they were to have...
They can defer the admission.
No, you cannot. Because you see, it's time-bound. The lectures are time-bound. They were to have started lectures last week. It was postponed due to some internal issues. So my information is that the lectures are starting this morning. Our expectation is that they will write to all... They know the 499. My good friend Maxwell Opoku Ajimai calls them Apollo 499. They know the Apollo 499, so they must send them text messages to come quickly, receive the admission letters, take steps to pay the deposits of 9,600, so they can process them for.
Anyway, it may well be possible that some people have received text. You're out there, you belong to the 499. You may have received a text message indicating that you should come to the school and start lectures. If you've received any such text message, please let us know here on the show so we can get to it. But we should also be looking at the possibility of these students not being admitted, even though you've given the directive.
It's right.
Parliament has given the directive. And it's interesting that
I don't want to say anything, but I shudder to think of the consequences that GLC will ignore directive of the Parliament of Ghana. GLC is a creature of statute. It is not even part of the judiciary. A lot of people have come into that mistaken belief. No, the GLC is born by Act 32. It is the representation that is geared towards a lot of serving judges. So it gives it that semblance. It is not. It's a normal state institution manned by senior public servants. They shouldn't do that.
Now, Jonathan, I'm sure you are in touch with some of the students, the 499 that's been affected. Do you have any indication that they probably have received any such text messages from the school?
As of this morning, none of my friends has been able to confirm that the law school has reached out to them with any such positive news. So I think we are still very much in the dark on that issue. But I just want to quickly say something to the honorable member. You see, we are skeptical. I'm part of the skeptics, who don't think that the GLC are going to obey the order of the House because there's precedent. And I pointed you to the time when we came to your house, petitioned the House, you investigated the matter, issued a directive to the GLC to reduce remarking fees, and nothing was done about it, and that was the end of it. And so we, the skeptics, rely on that.
What they did was we asked for 500, they were charging 3,000. We asked them to cut it down to 500. They cut it down to half, that's 1,005. When they came for budget performance review, they gave some reasons. And given that they had paid the monies to some of these professionals who marked the papers, and so it was difficult to go back. It was embarrassing to them. So they took our recommendation strongly, but they thought that they wanted to meet the examiners who marked the papers halfway. That going forward, they were going to implement our recommendation. So, yes, I can understand that we gave a figure.
They didn't fully comply.
They didn't fully take the figure into consideration because in the law, we all, even the court will want to listen to reasonable excuse. So they gave reasonable excuse. So we allowed them.
So Jonathan, are you still skeptical?
No, I still very much remain a skeptic until I see that the GLC has complied this time around, because the GLC has managed to build itself into an institution that's almost above the law. There was a court order last year, Honorable. Yes. Last year, the case of Ganaku and others versus the GLC and the Attorney General, there was another that asked them not to, continue with the practice. In fact, the first thing was that they asked them to make available the raw scores for the students who took the exam. That was never done. This is an order of the High Court. That was never complied with, and this matter went nowhere. And of course, you can understand, as he said, the GLC is made up of senior-most justices of the Supreme Court. It's made up of the Attorney General, nominees of, the President, the Bar President. It's a powerful institution, so I can understand if they elevate themselves to that stature. But in all fairness, we should all begin to act within the remits of the law, and I hope this will inform, it will redirect all of us to act accordingly.
Right. Thank you very much, Jonathan Alua. He's a lawyer and former SRC president, Ghana School of Law. Thank you for joining this conversation. But, Mr. Dafiameko, we are looking at the possibility that the GLC, as Jonathan is saying, they may again just justify or give a reasonable explanation why they can't admit these students. What next?
The reasonableness or otherwise of what they would say by way of not complying with our directive will not be founded. We are rather giving the directive on reasonable grounds. Parliament is saying you are already training over 1,000 students. You already admitted over 1,000 students and trained them through the Part 1 courses. They have progressed to Part 2. So if we were able to train over 1,000 students for them to progress to Part 2, there should be no basis why you shouldn't admit another over 1,000 students for Part 1. It's as simple as that. In any case, at the time you admitted over 1,000 students, there were other students also in Part 2 who exited last year. So now the last year admissions, they have now progressed to Part 2. In any case, as part of the reforms we are asking for, is to even empower the faculties to train their products so that we write one national bar exams. Look, Israel, about 20 years ago, only University of Ghana could train medical doctors. It became an issue. So UDS, Tech was encouraged to introduce, they began to produce doctors about 20 years ago. UDS joined. Now UCC has joined. There's Professor Kwakume's Family Health Medical School, private one. There's UHAS now. All these institutions are producing doctors, and yet we still say that we have the doctor general population patient ratio is poor. The lawyers in this country, according to the statistics, we are less than 6,000. or 7,000. We need more lawyers. We need more. Look, it's not every trained lawyer who practices who is a courtroom animal. There are a lot of lawyers who can do a lot of things. Samson is a courtroom animal, but he's still a journalist. And I believe that by being a lawyer, it makes him a better journalist. Yes, I have been in law class with medical doctors who were practitioners, but have come to train as lawyers. And I believe that having become lawyers, they would have become better medical practitioners.
That's like the Ghana Medical Association General Secretary.
Youngster was a year behind me. I even speak of those that I sat in class with. So there are chiefs who are training as lawyers now, just for the sake of what they do. A lot of people want to acquire legal mind.
Yeah. We'll see how that plays out. We're hoping that probably today we're going to hear some word from the General Legal Counsel, and maybe they will respond positively.
No, I think it's procedural. I did make the point that the directive will have to be communicated to them formally.
Okay, so you wouldn't know.
So the speaker, I believe that this morning the speaker will issue some instructions to the clerk, to Parliament, for them to prepare the directive formally and make a formal communication to the AG as well as the General Legal Counsel. I believe when that is done,
they will comply.
In the balance of lawyers and legal terms, when they are served with the directive, I'm sure there will be compliance.
All right. Now.